Good evening, and might I welcome you all to this European Law Institute webinar on the ELI Guiding Principles for Automated Decision-Making in the EU, where we will discuss that and the recently promulgated blueprint for an AI Bill of Rights promulgated by the Biden administration. The idea is to have a transatlantic dialogue, but motivated very much by the guiding principles that were set out in an ELI innovation paper. And we're very fortunate to have with us this evening, first of all, Teresa Rodriguez de la Harras Balelo, who is the author of the guiding principles. She's a colleague of mine on the executive committee of ELI, and she's an associate professor at Carlos III University of Madrid. She's been the Saroy Good Fellow at UNIDWA recently, and she has a huge number of qualifications. But tonight, her great interest is in this area of the law, and we are very grateful to her for coming and speaking to us about the paper. Now, to comment on the paper towards the end of their presentations, first of all, we have Professor Mark Rottenberg, who's president of the Center for AI and Digital Policy in the United States and an adjunct professor at Georgetown Law School. He's the founder of that center, and he has great expertise in this area, data protection, internet policy, open government, and AI policy. And he's published extensively in the field, serving on expert panels for the OECD, UNESCO, the UN, and many other bodies. And he's going to explain to us the blueprint for the ALI, for AI from the United States, promulgated by the Biden administration. And then he's going to mention the European aspects and also comment, and we'd be very grateful for this, on the ELI innovation paper. And thirdly, we're going to have Dr. Juha Hikala, who is going to speak to us about the perspective from the European Commission's viewpoint, other European views, and also to comment on the ELI paper. He, again, although he has, I think I would describe it, has either the advantage or benefit or distinction of not being a lawyer. He brings, therefore, from a non-lawyer's perspective, a great deal to this conversation. He's been involved in all aspects of this subject for a considerable period of time, and has published a great deal on artificial intelligence, plans for artificial intelligence, and looking how it's to work in a practical viewpoint. So we're very fortunate to have apart from a multinational discussion, a multidisciplinary discussion. I think that adds greatly to the perspective of what we can look forward to. And what we intend to do is we will have a short presentation from each of the three panelists, and then we will proceed, I think, to have a short discussion and invite questions and answers. Now, you should see on your screens the Q&A box. The chat box has, as I understand it, been disabled, but you've got the Q&A box there, and I shall look forward to seeing questions put down for the panel to answer. Please address it to a particular member of the panel if you want, or address it to all of them. And I hope you can be sure that we will have a very lively discussion, because in this area, there's always so much to talk about and so much to ensure that we get right for the future as AI comes to dominate our lives more and more. So without saying any more, let me ask Teresa if she would now introduce the ELI principles set out so clearly in her innovation paper.
Thank you very much, Lord Thomas. I'm delighted to be part of this transatlantic dialogue that indeed reflect to which extent different organizations are working on elaborating, promulgating principle on the responsible use of artificial intelligence and algorithm in social activities and economic activities as well. And I'm delighted to contribute from the perspective of the ELI, the European Law Institute, and I would like just to start by setting the basis and trying to describe the foundation of the ELI guiding principle on automated decision-making in order to establish this conversation, this dialogue among the different instruments and initiatives in order to see to what extent they are indeed principles totally, fully or partially aligned, and they are crystallizing in a kind of consensus on how should be the legal framework for artificial intelligence at the global level. In order to do that, if I may share a very brief presentation with you for the purpose of simply structuring my speech. And I would like to start by saying what is exactly the scope of this ELI guiding principle for automated decision-making. From the perspective of the material scope, these guiding principles are based on a very broad and definitely not surprising description of what automated decision-making are. As you can see, the ADM are defined as the processes, computational processes that are fed by input coming from a variety of different sources. They are processed by the system in conformity to certain predetermined or predefined objective, and with the use of different artificial intelligence techniques, deep learning, machine learning, and others, as for example, the Future Artificial Intelligence Act was initially detailing in listing in the annex. And the most important thing is that this automated decision-making will generate a wide variety of output, from rating, ranking, recommendation, but also declaration that may have a legal effect in the context of transactional purposes. We may have a credit scoring, but we also may have trading or investment advice, or even compliance in the context of RegTech and SupTech models. So the ADM that is defining the scope of the guiding principle is extremely broad and covered not only all these cases where we have an unilateral decision coming from the operator that may have legal impact on the affected person. As you can see, a variety of examples illustrating different automated decision-making. But also what I would like to add in that perspective is that, as you can see, the concept of the guiding principle is that the output of the automated decision-making may be in two different scenarios. The first one could be an input for a subsequent decision-making process adopted or initiated by the affected person. For example, the consumer relying on a recommendation proposed or generated by the automated decision-making, and on that reliance, adopting a subsequent decision to buy a specific product or to conclude a contract with a specific trader. The second scenario is where the output of the automated decision-making is a final decision that is going to have impact on the legal status or the contractual status of the affected person. For example, when it's a decision to refuse a loan application, what is a decision to hire a specific candidate, or is a decision to rank a specific trader for the purpose of being listed in a list of eligible candidates. So might be a final decision having impact on the affected person legal status. This guiding principle may cover as well situation where the automated decision-making is indeed within the contractual life cycle as well. So we are covering, at least we are embracing the situation where the output is, for example, an offer, might be an acceptance, might be a declaration in the context of negotiating a contract or renegotiating the condition of the contract. But it is certainly not the core of the guiding principle. And that is the reason why the current project of the ELI on algorithmic contract is indeed focusing on and diving into this algorithmic contract in more detail. But we believe that the bases are in the guiding principle. The guiding principle have been formulated on the assumption that there are a number of references, and we already see certain emerging principle in the different European Union instruments. DMA, DSA, the Future Artificial Intelligence Act, the Platform to Business Regulation, but these principles are scattered and they do not form a coherent and consistent legal framework yet for the purpose of using automated decision-making. So the attempt of the guiding principle, the aim of the guiding principle is to provide guidance for lawmakers and policymakers in developing a consistent and comprehensive legal framework for automated decision-making. And that is the reason why, essentially, the approach of the guiding principle is a private law approach. It is not a regulatory approach. It's an approach that comes from, as I will explain you in the different principle that up to 10, a total of 10, try to address. But essentially, the starting point, the starting question of the guiding principle try to answer is from a private law perspective. So essentially is to which extent we can consider that the decision adopted by automated decision-making or supported by ADM are valid and enforceable. To which extent we can apply to the full extent the functional equivalence principle in order to find a perfect equivalence between action, decision, settlement, or performance by automated decision-making and the equivalent human-driven action, declaration, or decision. Once we respond in affirmative to this question, the guiding principle tells to go further and try to establish and formulate a specific principle in order to determine to whom to attribute the legal effect, to whom to allocate the legal consequences in case that damages has been caused by the automated decision-making. And at the very end, the principle tried to provide the basis for answering the following question. Are ADM specific rules needed? We can see in the different instruments around the world, for example, a very good illustration is the Future Artificial Intelligence Act in Europe. We see a number of regulatory requirements: audit, monitoring, human review, traceability, transparency. Which are the impact of this requirement in private law? That is essentially the scope and the approach of this guiding principle. Let me just provide you in a few minutes, let me provide you a first overview of the main principle. And I would like by initiating with this very fundamental one. If we combine guiding principle 1 and 2 and 11, all the effort of the guiding principle gravitate around the following principle, the principle of non-discrimination against automated decision-making, that essentially is formulated as follows. As a general rule, automated decision-making shall not be denied legal effect, validity, or enforceability solely on the ground that it is automated. This fundamental principle is key. Is fundamental to build on building a legal framework for automated decision-making, but has to be necessarily combined with guiding principle number 1, when we try to ensure two different good practices, if I may, or best practices, if I may. The first one is the idea that automated decision-making should be designed and should operate in perfect and full compliance with the applicable laws. But which are the applicable laws? If we are talking about phenomena that might be new in many sectors, the applicable law should be the one that should be applied in case that exactly the same decision should have been adopted in a non-automated scenario. That would be indeed the threshold, the reference for knowing what is the applicable law to comply. But the other perspective is also very important, is the idea that automation should not be used as a way to circumvent, to evade, to elude the applicable law. That is essentially the idea of this guiding principle number 1, together with guiding principle number 2. Once we decide that there is a functional equivalence between automated decision-making and non-automated decision-making, it is fundamental to go further in order to ensure the adequacy of the existing rules. And in order to do that, we need to solve 2 problems. To whom to attribute legal effect? And as you can see, principle 3 essentially pivot on the concept of the operator. And the idea is that the decision adopted by automated decision-making shall be attributed to the operator. And guiding principle number 7, adopt a principle in relation to other problems. In case that this decision or the mere operation of the system cause damages, might be a robot causing body injury, or might be a credit scoring causing economic losses. In all cases, we have to ask the question to whom to allocate the risk and the liability. And let me just provide you with 2 designs that explain who are the main actors here. The legal effects are attributed to the operator. And this is important, and it's a very clarifying principle, because we know that one of the problems in understanding automated decision-making is the complexity of the ecosystem within these systems works. There are many actors involved in this ecosystem. The operator in our principle are the one on which 2 factors concur: control and benefit. The operator is the one who controls the automated decision-making, completely independent on whether it has been produced or not, programmed or not, monitored or not. In that case, is control the system and benefit from the operator. For example, using that in the context of an economic activity, in the context of running a specific economic activity. If we talk about liability, the answer is not unique, is not a single answer, because we have different scenarios that we have to bear in mind. Even if we believe that the operator is again the center of gravity, we realize that there are different scenarios to consider. We could be in a situation where the automated decision-making is regarded as a product, and indeed the proposal of the Commission in the directive on reforming the defective product liability is indeed incorporating automated decision-making in the context of the product, in the concept of product, and therefore we might be in a situation of liability of the producer. So this principle number 7, again, try to create or to place the operator as the first line vis-a-vis the third party, but definitely there are other scenarios to take into account. Principle number 4, I'm about to close, John, so please let me know if I am very close to the end, but I would like just to mention, if I may, a couple of principles. Let me know otherwise. The 2 principles that I would like to mention, if I may, is a combination of, I come back, principle 4, that is very well known, is the principle of disclosure of the automated nature of that particular decision. The idea that the party who is going to be the affected party should be aware, should be advised of the fact that an automated decision-making is involved in adopting that particular decision. And principle 5 and 6, in my opinion, even if they are quite obvious, they are still very important, is this principle of traceability. The idea that ADM should be designed in a way that enables the traceability of any decision when and to the extent that is required. We're talking about a prerequisite, but we're talking about a technical possibility. That doesn't mean that every and each decision has to be traced. We're talking about the possibility, and the possibility might be required, for example, when in principle 6, we need to guarantee that the decisions are not opaque and they are not excused. They are not becoming an excuse to produce or to render arbitrary, unfunded, on a reasoned decision, simply on the ground that the decision has been adopted by an automated decision making. And that is what we called the principle of reasoned decision. And let me just conclude with a question, because we are here in a situation where it's not easy to find a solution, at least from my perspective. We believe that this idea of transparency, traceability, and reasoned decision has a very important link with access to justice. So we have to be extremely careful in ensuring that the affected person has always a way, proportionate, effective, and reasonable, to challenge the question, to challenge the decision, to understand the reason, and to proceed accordingly. And that is for me the last slide, and I'm going to finish immediately. That is for me probably the principle that they are more difficult to implement. How to implement, to which extent, and on which specific mechanism, this principle of human review and human oversight, what that means exactly. And I would like to conclude with this question, with this open question. What that means that human review and oversight should be effective and proportionate and adequate. What that means exactly. And in order to show you the possibilities that we have, I would like to conclude with this table of comparison. If you take a look of the different solutions that we can find, for instance, in some of the instruments at the European Union level, you can see what is the proposal in the GDPR, you can see what is the proposal in the DSA, and you can see what could be the proposal in the future directive on platform work. We have here three different possibilities. Which one? Should we adopt a general principle, or should we adopt a case-by-case decision, or maybe a sector specific, depending on the type of interest and the gravity of the situation? I think that this is an area that requires discussion, and I would be very, very happy to have the opportunity to discuss with the panelists and the audience at the end of the session. Thank you very much, John.
Thank you very much indeed, Teresa. Can we now go immediately to Professor Mark Rottenberg to explain the US, recent US administration's blueprint, and to have his views on what has been proposed in Europe and also by the ELI. Professor Rottenberg. I'm afraid, Professor, you're on mute.
There we go. Let me thank the European Law Institute for the opportunity and the honor to speak with you today. Also to my colleagues at the Center for AI and Digital Policy who have joined us. Much of the work we do at the center reflects the participation of AI policy experts and advocates from around the world, and we're very pleased to be able to take their inputs into the work that we produce. And I also wanted to thank Teresa and again acknowledge the excellent work on the ELI guiding principles. I had the opportunity this summer to write a brief article for the newsletter, and noted the fact that it was remarkably timely that the guiding principles on automated decision-making came out just as the Court of Justice was issuing a judgment in the PNR directive case. And while a number of my friends in the civil society world were disappointed that the Court of Justice upheld the directive, they believed it is a form of mass surveillance that violates fundamental rights. I was actually struck by the analysis in the judgment that walked through the steps of distinguishing transparent automated techniques for decision-making that were accountable and provable, in contrast with machine learning techniques, which oftentimes are opaque and would appear to violate two of the principles that were set out by the ELI earlier. So I see these two tracks converging, and the contribution of the guiding principles, I think, will be very useful, actually for courts around the world, not just in the EU. I am going to provide an overview of the US Office of Science and Technology Policy AI Bill of Rights. And to do this, I need to give you the background. This will be a bit of a narrative, and then we will come to the document and then talk about the implications of the blueprint. I'll begin by saying that many of us in the United States were very excited when we saw an article appear a little over a year ago in Wired magazine, authored by the then director of the U.S. Office of Science and Technology Policy and the deputy director, calling for an AI Bill of Rights. It was a powerful commentary on the impact that AI systems are having on our lives in credit, in housing, in education, employment, and criminal justice. And really an urgent call for the United States to move forward a policy framework to protect fundamental rights. And as you know, over the last few years, the U.S. has been a bit reluctant to regulate in the tech sector, although I think that's changing now. And this was seen as a call to action from the White House's top science advisors in response to the increasing deployment of AI techniques. Almost immediately, we published an article talking about the next steps to move forward the U.S. AI Bill of Rights. We saw the recommendation from the Office of Science and Technology Policy as a starting point, but clearly there's more work that needed to be done. And I will just quickly go to the end. I think some people will appreciate our key recommendations for how to move forward the Bill of Rights. We proposed a small number of clear, powerful principles, perhaps anticipating the work that was underway already from the European Law Institute. We encouraged the Office of Science and Technology Policy to build on prior initiatives, including a framework that I had helped draft called the Universal Guidelines for AI, which received support from technical societies and legal associations. We noted, as we oftentimes need to in the U.S. political process, of the importance of proceeding on a bipartisan basis. There was no necessary reason to politicize the recommendation from the White House. And finally, and you'll see the significance of this point in a moment, we urged the Office of Science and Technology Policy to not delay its action. We observe that there have been many efforts, literally hundreds of efforts, to draft frameworks for AI ethics. And while these are, as we said, well-intentioned, they have not done very much to curb unfair business practices or government surveillance. So at the outset, we supported the initiative, but then actually time passed. There were several meetings held in Washington, D.C. There was some discussion of the elements of the AI Bill of Rights. This is, by the way, a page taken from our website. I think you'll find it fairly easily if you do a search simply for AI Bill of Rights. And before we get to the outcome, I'll note that we had gathered a number of resources, including this article that I've just mentioned a moment ago. But we also launched a campaign. And in the campaign, we wrote earlier this year to then Director Nelson about the need to move forward the proposed Bill of Rights, as she and the former director had urged earlier. We made the case for the importance, particularly in the United States, of creating some type of framework regulation, and we continue to build this initiative. Subsequently published another article, Time to Act Now, on AI Bill of Rights. I'm sharing with you my strong interest in the outcome of this initiative. And then with another colleague for the Council of Foreign Relations, we talked about the need for the United States to move forward the proposal. It was, in fact, our final recommendation here. As the OSTP had said, powerful technologies should be required to respect our democratic values and abide by the central tenet that everyone should be treated fairly. we said that should be the cornerstone of a U.S. national AI policy that will advance international norms for the governance of AI. So I'm sure you're wondering at this moment, what was the outcome of all this effort and organizing? And the good news, of course, is that this fall, the Office of Science and Technology Policy did release the blueprint for an AI Bill of Rights. It is a long document. There's a lot of descriptive material contained within the document describing many of the challenges that Dr. Lander and Dr. Nelson had identified in the initial article. I think the easiest way to approach the document is to look at the summary that was provided by the White House. And so I'm going to take a moment to share this page with you. This is a press release, but also includes a useful overview of the 5 key principles. And you will see here the 5 pillars in the blueprint for an AI Bill of Rights. Systems should be safe and effective. There should be protections against algorithmic discrimination. There should be safeguards for data privacy, notice in some form of explanation, and a number 5th principle is to establish opportunity, we might say a human in the loop or human review, human alternatives consideration, and fallback. So these are the 5 key principles that undergird the blueprint. Now, when the announcement was made in October, one of the criticisms that the White House received, which I thought was a bit unfair, was to say, well, this document has no legal force. It's called a Bill of Rights, but in fact, no rights are announced, or at least no rights are established in law. First of all, I think this misunderstands the role of the Office of Science and Technology Policy. We would think of the blueprint in EU terms essentially as a white paper, an outline, a proposal for future action. But perhaps more precisely, as I thought about the significance of the blueprint, I recognized a rather remarkable similarity with another report that the United States government had issued almost 50 years ago. This report, which is very influential in the United States privacy world, was called Records, Computers, and the Rights of Citizens. This report also established no rights. But like the White House Office of Science and Technology policy report, it describes a new problem related to technology, implicating fundamental rights, and sets out framework principles that could become the basis for legislation. And it is, in fact, true that almost immediately after publication of the 1973 report, the United States Congress went to work on legislation, and we passed in 1974 the Privacy Act, which is still the most comprehensive federal privacy law. So as we think about the significance of the blueprint for an AI Bill of Rights, I think it's very important to understand that this could precede a legislative framework. It could provide the foundation. But there are other similarities as well, which I thought were quite striking. The 1973 report, for example, had 5 key principles, which actually look quite similar to the 5 key principles set out in the blueprint. Also, oftentimes in the United States, we talk about fair information practices that describe the rights and responsibilities associated with the collection and use of personal data. And as you would understand, in the realm of data protection law, these rights and responsibilities are applied asymmetrically. So we give the rights to the individual, and we place the responsibilities on the organizations that deploy these new techniques, these new systems. And in fact, if you read the blueprint for an AI Bill of Rights, it carries forward that same approach to the allocation of legal liability, which is, as I said, quite familiar in the world of data protection. So I've decided to call this fair AI practices, once again, assigning rights to those who are subject to AI-based decisions and placing a responsibility on those who make the decisions. And I think this is also very much in line with the ELI guiding principles. So let me go to my last web page here. This panel, of course, is very timely because the EU and the US are about to meet in Washington, D.C. for the third session of the Trade and Technology Council. And many of us are hoping on the US side that US negotiators will carry forward the recommendation from the White House, from the Office of Science and Technology Policy for the blueprint for an AI Bill of Rights. We see that as a possible basis for a transatlantic bridge. You will find this article online as well. I won't try to summarize it, but it goes into a little bit more detail as to the dynamics on both sides regarding AI policy. And I guess my final concluding point on the US side is there's more work to do. We need to carry forward the blueprint for an AI Bill of Rights. We need draft legislation, and we need to put in place common framework principles between the EU and the US to ensure that AI systems are trustworthy and human-centric.
Thank you very, very much indeed for that very illuminating presentation of these very recent developments from the White House. Now, can we turn, before we have the discussion amongst the panel, to the European perspective from Dr. Juha Hikela.
Thank you very much indeed, Lord Thomas. Thanks, Teresa. Thanks, Mark, for these very interesting comments and explanations. So I would like to take a step back in the sense that you all will have heard about the AI Act, and you may be familiar with it. I will perhaps explain the rationale to some extent, but I would like to perhaps briefly indicate the kind of rationale that we have in dealing with this technology. So the European Union, when we started looking at AI several years ago now, from the very beginning, we felt that it was necessary to deal with both the technological aspect and the non-technological aspects of this technology. And Commission communications may not be very widely read except in the professional circles, but the first document, the communication outlining our AI strategy, was published in April 2018. I think this audience will be familiar with it to a large extent. And in that already we outlined, set out our approach and the need to deal with not just the research and industrial capacity and excellence, but also deal with the socio-economic impacts and the legal and ethical aspects of artificial intelligence. Because in our view, it became clear when we discussed this several years ago that is the way that we should do AI, that is the way that AI should be approached in Europe. That would be the right way, the right kind of AI for Europeans. Also, given the calls that we had and given the kinds of comments that we received. And then, of course, we developed, because we had been, of course, the European Commission is not just a regulatory body, but also a funding agency. So in that sense, we play a role which is perhaps unique in many ways. And we had been funding research and innovation in this area, in robotics, cognitive systems, AI. In the past, nobody wanted to use the word AI. We called it cognition or cognitive systems because AI was more like a two-letter, four-letter word, if you like. And we felt that there was need for us to do something at the union level, and therefore we outlined this approach, which then led in several developments. First, we set up the high-level expert group on AI, an independent expert group which advised us on ethical guidelines, gave us the ethical guidelines. But at the same time, we also worked together with the member states and produced a so-called coordinated plan to coordinate investments and policy measures in this area. And then finally, of course, now last year, we put forward the proposal for a legal framework. So this is, in our view, important because we have this union of 27 member states. We want to make sure that for such an important set of technologies that we have a uniform approach and that we avoid fragmentation. Fragmentation on the one hand from the perspective of the legal and ethical landscape, but on the other hand also from the perspective of the single market, because we have a single market. So that's one of the motivators behind it. And of course, AI systems, we felt the need to propose regulation because they have certain characteristics which will be familiar, which cause certain complications. They are very complex, they are opaque, unpredictable, they have a certain degree of autonomy. They can learn and adapt their own behavior. And this leads to a number of different kinds of complexities, safety risks, fundamental rights risks, but also raise questions about enforcement. They can raise legal uncertainty and lead to mistrust. So in fact, we see that trust is the key concept here, because trust is a sine qua non for the uptake of AI, and that is the sine qua non for the benefits to materialize, because ultimately we think that it's a very powerful set of technologies, useful set of technologies that can help us in many different ways. And then the approach that we adopted for this is a risk-based approach, as you probably are aware. So we wanted the legislation to intervene where we thought it was necessary. And that's where we felt that if we have risks to safety or to fundamental rights, those are the situations where we then should have measures in place, have requirements on these systems. It is based on quite a broad definition, which is closely aligned with the OECD definition, and that is done on purpose to be neutral on the one hand, and to cover a broad range of different kinds of AI systems. And in this risk-based approach, we have this, you can picture it as a pyramid. So we are talking at the extreme level of an unacceptable risk. So these are the kinds of AI systems or use of AI which have been, which are proposed to be prohibited. So this is subliminal manipulation resulting in harm, exploitation of vulnerable groups like children and mentally disabled persons, a general purpose social scoring, and remote biometric identification for law enforcement purposes in public places. And then, if you like, the core of this is then the high risk category of systems. So these are then safety components of regulated products. So products which already have requirements in existing sector-based legislation, so medical devices, for example, or machinery, and they have therefore a third-party conformity assessment as part of the market mechanism. And then we have systems in certain fields, biometric identification, categorization of persons, management and operation of critical infrastructure, education and vocational training, employment and workers management, access to certain essential public and private services, law enforcement, migration, asylum and border control, and finally the administration of justice and democratic process. So for these systems then certain requirements will apply. They concern the data used in training, validating and testing the systems, There has to be a certain traceability and auditability, so documentation set up, transparency, human oversight, and robustness, accuracy, and cybersecurity. And then there have to be then, of course, also a risk management set of risk management processes in place, which the providers have for this. And of course, this all then in the light of the intended purpose of the AI system. So that is the rationale behind it. And there is this product safety consideration, which is quite important here in the rationale of this. Now, maybe then, and I should add that two things maybe. On the one hand, the list of high-risk systems is an annex to the proposal, and that can be revised because obviously in an area which is moving very fast, there needs to be a flexible mechanism to adapt the legislation if the need arises. So that is an important aspect here to take into account. And the other thing that I would like to mention is that this applies to providers who want to place AI systems on the EU market. So it applies equally to players inside the union and outside the union, which want to place these their products, AI systems on the market. So that is in a nutshell the kind of rationale in it. Then if I perhaps relate this to some of the US work and what's going on in the US. I am personally involved in some of the cooperation with the US, and when the Bill of Rights was published, we felt that this was a step in the same direction as what we had been doing in the EU. We were encouraged by this because we felt that if anything adds to our like-mindedness in this regard. Be of the aspects that we also engage in the European Union is international activities. So we want to be part of coalitions which advance the responsible stewardship of AI, the responsible governance of AI to the extent that it is possible in an international setting. So we feel that this technology needs to be advanced in a responsible manner. And we felt that the US AI Bill of Rights, or the blueprint, is a very interesting and valuable contribution in this regard, which, if anything, brings us closer in alignment. Although, to my knowledge, there is no federal level legislation in the pipeline in the US, there is, however, and Mark mentioned this, perhaps also an increasing realization that maybe something could or should be done. I see this translated into state level action. So there are states which have introduced some legislation, which would seem to be done in similar ways to what we are planning to do in the EU. Also, I understand New York City has introduced rules for the use of AI in recruiting services. So there is clearly some movement there. A few years ago, when I was speaking at public events like this, I was often asked, why do you bother? Because everything is free in the US and everything is state controlled in China, and you're going to lose out no matter what. I tend to say that maybe there are no constants in this area, or that one should not expect things to be cast in stone quite as firmly as it would seem, because attitudes may change. I think one thing that changed, I noticed very clearly, was the reactions to the GDPR a few years ago. So there was a very negative public reaction at any event that I was speaking at, until the Cambridge Analytica scandal happened. And surprisingly, or unsurprisingly perhaps, then the next event I talked to, there was a lot of positive comment about the GDPR and the fact that at least in the EU there are some safeguards, and maybe it is not such a great idea after all that everyone operating in this space has all the data available at will. So this is one thing that I would perhaps like to highlight, that things may be moving. There is also international activity. Interestingly, the UNESCO recommendation was adopted about a year ago. That is a very diverse body, of course, compared to the European Union, where obviously there is much more homogeneity. And so obviously that is a very different kind of instrument from the AI Act in many ways, but nevertheless, I think that perhaps also shows that there is increasing awareness of the need to perhaps do something about this. I think that this kind of change in attitude is also, as I said, visible in the work that we do with the United States in the Trade and Technology Council. Now, I would like to conclude by making a few comments on the ELI work. I very much comment this work. I find it very interesting that you go into this, you really pick it apart and go to the bottom of the things. I found the explanation by Teresa very, very enlightening and helpful in the way that this was set up. And the fact that the cornerstone is actually principle number 2 under non-discrimination, that's quite interesting. I would assume that not everyone necessarily agrees with that, because they would see that it that perhaps automated systems should be discriminated against, if anything. And that's, so I find that very interesting. And I think that a lot of what has been detailed here is obviously something that is already contained, as you also mentioned in the document, is contained in the legislative proposal of the European Union. Also, one thing that struck me was that very broad definition, which you also acknowledge is something that leads to you dealing with more than just AI. So it covers many more systems than just AI. Obviously then this makes it in its scope much broader in some respect. Maybe just as a final comment, there was one particular principle that I would like to sort of relate to a personal anecdote, which was principle 6 with this reasoned decision. So this is the kind of no excuses clause, if you like. So the use of automated decision making is not an excuse for bad decisions or wrong decisions. This, of course, applies to also very rudimentary, crude technological systems. I remember, 15 years ago, I had an issue with an urgent payment I had to make, a bank transfer. I could use a machine for this free of charge. It was out of order. I had to go to the branch to do this, because I need the receipt. So I could have done it online, of course, but I need the receipt immediately for a very particular reason. I realized later that I was charged for that. The bank had changed its fees in the meantime, so any payments made in the branch were charged. And when I complained about it, I was told, well, we can't change it because it was done automatically. It's done automatically by the systems. And I said, well, surely you must have some way of overriding the mechanism, the automation here, because obviously I knew that I could avoid charges if I use a machine, but where I could have got the receipt as well, but it was broken. So of course, that was also very poor customer service. And of course, I left the bank, not just for this, but to show you that some of these principles go even deeper than automated decision making. So I think I'll stop there. Thank you very much.
Thank you very, very much indeed for that very interesting personal anecdote and for your very full discussion of the Act. And I'd like to, if I may, take up one point you made. You described the blueprint as a step in the same direction as the AI Act. And I wondered, before we go to more general questions, if I could ask each of you, because it seems to me there is a great deal of common ground between what is put forward in the ELI principles, the blueprint, and the EU AI Act. Where do you think there is common ground? And where are the differences? And I think possibly it's very important to highlight the differences, and then to work out how we build on the common ground and move forward to eliminate the differences. Teresa, would you be able to start?
Thank you very much, John. Indeed, the two presentation has been very insightful in order to understand the different perspectives, but also the commonalities in the approaches. Probably, in my opinion, and Christina Ramberg in one of the questions indeed raised that point, so help me to use it for my reply, is that the ELI principle in particular are essentially gravitating around the idea of being minimalist in the approach, being functionalist in the sense that to the maximum extent possible, technology neutrality and functional equivalent will be the driving forces to translate into the automated scenario the existing rules, the existing concept, the existing principle. So probably the first point that I raised, John, is that the ELI approach is a private law approach, but it's essentially a functional equivalent inspired approach. The idea is to minimize specificities, minimize the additional regulatory burden, minimize specific rules in all these situations where functional equivalent suffice and functional equivalent help us to find the bridge between the existing rules and the new scenario. That would be for me the different. Because on the other side, I see a lot of commonalities. So I think that there is this idea of ensuring common values, common element on safety, security, non-discrimination. That is definitely a common ground in all the different approaches. Thank you, John.
Well, thank you very much indeed. Can I then ask Mark Rottenberg for his view on the same questions I asked Teresa, namely, where is there common ground? What are the differences? I'm afraid you'll do what I did a moment ago, using the most widely used word in the English language, you're muted.
Yes, it must be an AI in the background. So first of all, of course, we share a common heritage. And I think it is, again, worthwhile to go back to the U.S. Privacy Act of 1974, which we would call a data protection law. And that law shares many similarities with the Data Protection Directive and then with the GDPR. And you see the principles precisely of fairness, accountability, transparency carried forward in the modern legislation, such as the EU AI Act, and also on the US side in the blueprint. And as I said, I think this is a common heritage, and we would not be surprised that the automated systems that are deployed should be fair in the determinations they make. But there's another significant commonality in the contemporary era, and that is that both the blueprint and the EU AI Act recognize that we're talking about decisions about people, that's the ADM piece, but we're also talking about safety and security, because we know that AI systems can be deployed to manage health systems, to manage electric grids, to manage the Internet of Things. And in those settings, personal data is not a key component, but the automation of a system and the possibility of a system being autonomous or semi-autonomous does raise real public safety concerns. So both of those, recognition exists currently in both the EU and the US approach to AI. Now, the difference, I would say, frankly, is that the US development of AI policy is still in the very early days. So it's really a matter of maturity with regard to carrying forward principles into legislation. But I do think these paths will converge. And as I said, both in the common heritage and in the current formulation, there is a lot of similarity.
Thank you very much indeed. And can I go to Juha Heikkilä? I also think it might be wise if you could also comment on Professor Ramberg's observations made in the fourth question, but you might want to come back to that separately.
So I can only concur with what was said before about the similarities of common heritage. So that is certainly something which is reflected in the values, and that is very clear in the first statement, the so-called Pittsburgh Statement of the Trade and Technology Council. So the US and the EU both feel that this technology has a lot of promise, but it should be used responsibly, and that it should be for the benefit of our citizens and societies. And we also, in that statement, state our objection to rights violating uses of artificial intelligence, such as social scoring. So there is this value base which is quite strong, and that is something that both subscribe to. And then another aspect which has not been mentioned yet is that in that very same statement, in fact, both the EU and the US indicate that the policy responses measures should be proportional to and based on the risk that is posed by artificial intelligence systems. So the risk-based approach, which we introduced in the AI Act, is also something that the US considers to be the right kind of approach to AI. So in that regard, we are more aligned than perhaps many would assume or would have thought. In that sense, certainly there is a similar kind of approach. Differences. I mean, this is obviously speculation because I cannot predict what the US government is planning to do, if anything. But it could be the case, for example, that if the US government decided to legislate on AI, it could go for a sector-based approach. This is a possibility, of course. We decided to have more of a horizontal approach. Some comments I've heard from the US would suggest that there is certainly, at least among some circles, preference for that. Mark would, I think, be better informed to comment on that. But I have a feeling that this could be one difference. And then, of course, another question where there could be, this is again speculation, could be difference, is what kinds of risks are considered to be high risk if then this risk-based approach is implemented in any kind of policy and regulatory measures. So those are my comments on that. On the EU approach and legislating, I think I would like to highlight that for us it's very important to strike the right balance between innovation and protection. That's why at the beginning I indicated that we have and are still funding this technology, supporting this technology because we think it's useful. And for us, it's very important that we have a thriving AI industry and AI research community in the EU, and that innovation can thrive in the Union. This is certainly one of the key aspects that we take into consideration, and we certainly do not want to over-regulate. However, not regulating from our perspective could, in the worst case, lead to a backlash against this technology. And if there's a backlash, that means there's a almost complete rejection of it, and that ultimately then would prevent from the benefits from materializing, and that would certainly be a worse alternative. So regulation, in our view, can also support innovation because it creates legal certainty. And if it's done the right way, which we aim to do, it can actually help. So in that regard, also I remember a comment from a major US company, in this case on the GDPR, saying that at least they know what the playing field is like. They may not like all the aspects of the GDPR, but they have certainty about what is there, and they don't need to second guess anymore what is perhaps to come and so on. So they know, and some of them are of course applying that also elsewhere outside the EU jurisdiction. Thanks.
Well, thank you very much indeed. May I, we've had, I think, some questions raised. Two of them have been answered, I think, by the talk. But can I, while people are thinking of more questions they would like to ask, can I pick up a point and ask really Professor Rottenberg this? I think one of the issues raised by Professor Rottenberg is it better to try and adopt a principles-based approach, keeping it relatively simple and using analogies with existing law? Or do you see a benefit in going down the line of more detailed regulations? I think Dr. Juha Heikkilä has made a very powerful case for wanting some kind of regulation. But what is your view on this point?
Well, a lot of my expertise is based on the comparative analysis of US and EU privacy and data protection laws. And I've been struck, first of all, by the effectiveness of the GDPR as a horizontal instrument. I think the simplicity in that approach reduced compliance cost, made it more understandable, and easier to enforce. And the contrast on the US side, of course, is striking because we have dozens of privacy laws, depending on the sector, the jurisdiction. Even within sectors, we have overlapping privacy laws. And frankly, it's quite complex. I don't think it always produces the outcomes that are intended. So at least as a starting point, I would say there is clearly a preference in this domain for a horizontal approach as opposed to a sectoral approach. Now, if you ask the question, can we do this best by framework legislation? Do we need detailed regulation? I had the experience working in the United States Senate many years ago, drafting a privacy law, and we were able to get quite a lot done by statute in just about 2 pages. I've seen other privacy laws, including our health record privacy law, which is over 900 pages long in the regulations. I would take the simple approach over the more extensive approach almost every time, particularly, and I think Teresa has made this point well, when you're trying to legislate in a technologically neutral fashion, you have to be careful that you don't find yourself writing regulations in response to the technologies of the day. You really have to focus on the underlying functionality if that is the behavior you are aiming to regulate. So I would say to keep it simple and to keep it horizontal is the best approach. I speak these words knowing that I think the AI Act is up to about 99 articles. I don't think it's 900 pages, but I'm sure it's more than 2 pages.
Teresa, can I ask for your comments before I go back to Dr. Juha Heikkilä?
Thank you, John. This idea of a principle-based horizontal approach as the optimal one for starting, for ensuring the proper adaptability to the progress, the technological progress, I think that works particularly well when we are talking about private law aspect. I think that the functional equivalence and the technological neutrality are perfect principle. They are suitable for private law aspect. And that explains probably why we can work very, very effectively when we are talking about algorithmic contract, in particular if they are business-to-business algorithmic contract or automated decision-making in private scenarios. This principle work very well. It is true, however, that doesn't mean that these principles are going to be in an isolated or in a vacuum. They have to interplay with other regulatory and maybe sector-specific approach. And that explains, for example, that even if we promote this principle of non-discrimination, and I completely agree with Juha's comment, non-discrimination doesn't mean that we could imagine in many sectors, in many situations, as the Artificial Intelligence Act aims to do, limitation, prohibition, or additional requirement because there are specific risk to mitigate or interest to protect. So probably the perfect standard would be to combine these two approaches, as minimalistic as possible in private law aspect, and sector-specific when is needed, but trying to make this distinction. In many cases, private law transactions are not requiring a specific, complex, interfering regulatory intervention. It's not needed if we can work with this minimal approach of the functional equivalence.
Thank you very much. And we've just had a further comment that's come up in the Q&A from Professor Christina Ramberg in relation to why she thinks, an additional reason why she thinks the approach advanced in her earlier answer or earlier question is important. And that is, she believes that the having something that is too specific presents essentially the risk of a safe harbor or safe haven for owners of present technology and discourages future new inventions. But I was going to ask Juha Hilaka for his views on that and how you get something that is really horizontal, but then relatively simple. And I think that therein lies the conundrum.
So, I mean, the way that we approach this, so addressing certain uses of AI, which we think carry too high a risk, it's not regulating the technology as such, but it is certain aspects which are harmful. That's one aspect that I would like to highlight. The second is that we intend this to be flexible in the way that it can be revised and in the way that it can then respond to the changing landscape and the evolution of this technology. We think that this kind of an approach gives the required flexibility to deal with this and to be able to handle this. And therefore, we would say that this does not, at least in our perception, this should not create major obstacles to innovation. Now, I read also that there were certain players in the field which want this regulation to if you like, consolidate their position. It's not necessarily the experience we've had in reaction to this AI Act. Of course, there are risks related to, so any way of legislating, regulating will obviously come with certain potential issues with it. I'm saying this, of course, I'm speaking as a non-lawyer, as was introduced earlier, but this is how I would see it. So I cannot comment on the 19th regulation because I'm not sufficiently familiar with that and the issues that came with it. But certainly for us, the technology landscape, its development, and the ability for the EU players in the field to develop this technology and produce useful and beneficial applications is a very important factor in our consideration.
Well, thank you very, very much for that very full answer. Now, could I ask one question to the three of you, really? I mean, it obviously is important that there is as uniform approach as is practical. Maybe some systems require more detailed regulation than others, but the underlying principles ought to be very similar for states that share similar democratic values and personal values, as each of you has made clear. But what seems to me to be important is that if we are to develop systems of AI that help us all, it's obviously much cheaper if we can develop systems that are interoperable in each of the communities concerned. How do you, each of you, see are working to achieve a much more precise common objective in those areas where we're not quite there yet? And could I ask you, Professor Rottenberg, to start on that point? Again, might I ask you to unmute?
Two excellent questions you've raised. This phrase, democratic values, clearly resonates when we talk about AI policy. And in fact, it's the focus of much of our work at the center as we try to assess national AI policies and practices against a rubric for democratic values. So we need to find, how do we translate that phrase into concrete outcomes? And we've developed a methodology that we think helps with this. Also, in practice, does show a high degree of commonality between democratic nations. But the second phrase you also use, which is in wide use, is interoperability. And I think we need to be careful with this phrase. Speaking from a technological viewpoint and talking about, let's say, the size of paper and railway tracks and the design of wrenches, interoperability is a very important principle because it allows us to put devices together so that they can work together. And from a design perspective, it's clearly an important goal. But interoperability with regard to legal systems, I would actually say, is quite problematic. Because if we've established certain standards, let's say for the processing of personal data, we don't necessarily want those standards to be interoperable with another legal system that doesn't afford the same degree of protection. And we would say this across almost any domain involving public safety, consumer protection. We try to establish a high standard, and we look for equivalence in other jurisdictions, forms of reciprocity. So, as I said, this term interoperability is critical with regard to the design of systems. But as to legal standards, I think we need to be careful because it is too oftentimes used as a basis, let's say, to permit trade in circumstances where, in fact, one jurisdiction does not respect the standards of another jurisdiction.
Thank you very much. And Teresa, can I come to you next?
Thank you, John. I would like to build on precisely this idea of interoperability. And I completely agree that interoperability is a fundamental feature of a global digital society. It's key that we ensure from a technical point of view this level of interoperability. But I completely agree with Mark in this idea that interoperability is a technical aspiration, or is a technical feature, a technical factor. How we are going to ensure interoperability from a legal point of view? From a legal point of view, interoperability is essentially mutual recognition or reciprocity, sorry about that, in the legal effect. And so we have to work precisely on ensuring that we have threshold, or we have a mechanism to guarantee precisely this kind of mutual recognition. For example, at UNCITRAL level, has been just adopted a few months ago, a model law on digital identity, mutual recognition of digital identity and trust services. That is indeed the international reflection of the European digital identity regulation. So how to project this European regional based on a regulation that is going to be directly applicable to other member states in the context of a global standards where there are different jurisdictions involved. And the idea has been precisely to develop mechanism for mutual recognition based on certain minimum standards, either ex ante, either ex post assessment of these standards. Maybe we could use the same idea for the purpose of mutual recognition of decision adopted by automated decision making at an international level. Trying to develop legal framework within, we ensure that the common minimum denominators are guaranteed, and only when that is guaranteed, we can ensure this mutual or reciprocal recognition among the different jurisdictions. That could be a way to proceed.
Well, thank you very, very much, Teresa. And can I come next to you, Dr. De Henrique, and ask you the same question?
Right. So it's probably better if I comment more on the technical aspects of interoperability. So there, for example, this is something that we are working on with the United States. So one of the topics that we discuss in the Trade and Technology Council is evaluation and measurement tools for trustworthy AI and risk management. So, and there we are sort of exploring to what extent we could perhaps have interoperable risk management settings or risk management frameworks. And there it is felt by both sides that this can be quite useful, regardless of what legislative or policy measures are taken. But this is felt that this could be useful also because it can then support standardization activities. And the AI Act, of course, will be implemented by means of so-called harmonized standards. So the requirements, the 5 requirements that I mentioned at the beginning, those will be then implemented by means of standards on the basis of a standardization request by the European Commission to European standardization organizations. They can, of course, use international standards if they are appropriate and applicable. But the common ground that we are seeking with the US, and we can do that also with others, can be very, very useful in this regard. And therefore, it can support the policy and legislative work, even if the conclusions were different and even if there is no legal interoperability as such. Now, of course, we have in the case of the GDPR, there are then, of course, these kind of equivalence considerations, or in some cases, the legislation in another jurisdiction is considered to be equivalent, which then allows the free flow of data. So there, of course, we have that aspect which has been then useful. So that's what I would like to comment on that particular question. Thanks.
My final query. Let me just ask one. Professor Rottenberg has, Professor Rottenberg has come back with a comment saying she's happy to learn about the cooperation. Important to have a similar approach, not only in order to enable commercial exchange between us, but mainly in order not to make the same mistake as with e-signatures, when practically all technological developments made in the US, which at the same time created a more favorable legal infrastructure than the EU. And what I was going to ask, did any of you have any comments on that? And then I see that the clock is marching on. But are there any comments on what Professor Rottenberg has commented on that anyone would like to come back on?
Sure. I'll make just a brief reference to my 2-page privacy bill, which was drafted and adopted by the US Senate back in the 1980s. And the aim was to protect the privacy of video rental records. Some of you may recall that we had video cassettes once upon a time that we put in these players, and they were attached to our television. You probably have display of consumer electronics from the 20th century in various museums across Europe. I know we have those exhibits in Washington. But the joking aside, when we drafted the bill, we said the aim would be to regulate records associated with video rental and other similar AV services, audiovisual services. And that qualifier turned out to be extremely important because as streaming media services emerged on the internet, such as Netflix and Hulu and others, people immediately asked the question, well, is this law that was written for video cassettes going to provide protection for the new streaming services? And the courts answered yes, because of the phrase that we had included. We didn't know about streaming services in the 1980s. This was quite some time ago. But again, following Teresa's lead, to the extent that it's possible to talk in technologically neutral terms, or to at least to try to anticipate other similar services in the future, I think the law ends up being more durable over time as technology evolves.
Any comments from Teresa or Dr. Hichler? No.
Thank you, John. Just to echo Mark's remark, this idea, because Christina, Professor Rottenberg, was referring to the problems related to e-signature, because indeed was considered a deviation from a pure and a sound and robust technology neutrality approach. And so just completely agree with Mark's explanation, how important is to define and design legislation with a real technological neutrality approach. That is absolutely fundamental. Thank you very much.
Any further comment? No. Well, I see the time is now advancing to the end, to the time we're just about to go beyond our allotted time. And I know it's my duty as the chairman to ensure that that does not happen. But can I do two things? One is to thank the panelists for what has been an extremely interesting and lively discussion, and preceded by a very valuable explanation of the three different approaches that have been put before us. It's been wonderful, and if I may thank on everyone's behalf them for the clarity and concision of their explanations. We're all, I think, deeply indebted to you. And secondly, an observation I would just like to make at the end. It just seems to me that if we can future-proof where we go, we can be technological neutral, but we try and find that we can express, maybe not quite as briefly as in the summary of the US blueprint, the fundamental values or principles which we seek to embed for the future, because it seems to me that safe and effective systems, protection against discrimination, privacy, a proper explanation, and human alternatives, and you may want to add reasoned decisions, and the more controversial matter of no discrimination against the use of AI. I think to try and embody someone, or if work could be done to embody principles that then the detailed procedural system in each country could be looked at, would, I hope, mean that we can make much greater progress. Because there are others who may have a very different view, different states' view, not that of a liberal democracy, as to the use to which AI can be put. And we, I think, as liberal democracies, would wish to see ourselves, A, making great technological progress in our own systems and using them to underpin our way of life and our freedoms and our democracies. But thank you all very much indeed. It's been a fascinating evening, and I'm grateful to have the privilege of chairing it. Thank you.
Thank you.
Thank you very much indeed for the invitation.